Honorable members and all of you colleagues who have just come out of the tea break. I indicated before the tea break that I would want to make a few and very concrete way forward proposition, borrowing from Honorable Maneli's terminology. Maybe before I make those points, there might be incoherent here and there, but I tried to do that. I think it's important as part of our context to indicate that we are operating, and this would have been very much ventilated in our meeting of Friday, the 2nd of June, as a committee. We are operating within a tightly determined timeline within the 22 days that we have been assigned to complete our work. We have been given 4 million. There is no intention, as we indicated on Friday, to extend those 22 days. There is no intention whatsoever to deplete the 4 million and ask for more money. We're very clear as a committee about that we need to work in such a way that we work within budget. It will be a bonus if we work even less than that 4 million. But there's certainly no intention to go beyond it. We've worked in a very difficult way to get to that point in the first place. And there's just no way that there's another avenue that must be opened up for some possible depletion of that 4 million. I want to start with that and be very clear about that, in line with our discussion as a committee on Friday. We've also been very firm and clear throughout this process about respecting the need for ensuring that there's legal representation of the public protector. We have done everything else to ensure that that happens. And up to today, as I speak, the PP has not been denied any legal representation. Of course, we heard from the representative of the state attorney, Mr. Chowe, and a follow-up made by Honorable Melder on that issue, that there would have been objections, and therefore the assistance intervention of the state attorney declined. So as indicated, therefore, colleagues, in the meeting on Wednesday, we have taken numerous steps and made several interventions to assist the PP in securing legal representation. On Wednesday, I took you through chronologically from the point when we were told, before there was a lack of funds, we were told that the PP legal team has not been paid. Something that was not in the terrain of this inquiry. Myself as a chair went out of my way to ensure that happens, and things started moving. So I would have taken you through step by step all of the kind of attempts and interventions that were made. Unfortunately, we find ourselves in this position that when we take a step forward and we think we have made progress, then there is a setback of sorts. So it's become a DNA of this inquiry of late, since February and March, that we would pick up a new hurdle, we attend to this new hurdle, another hurdle is put in the way of this inquiry continuing. Unfortunately, this committee does not have control or direct the budget of the PPSA, and the PP has not been able to move a chosen council on their fees. Remember, we spoke about on Wednesday, and as a new hurdle. Once there was an appointment of the senior council together with the juniors, then the next new hurdle was the increase in rates in terms of the fees. And I've indicated this point, we're constrained by this ring-fenced 4 million to complete the process and to do so in a manner that is fair. So these setbacks have been caused by various factors, and I'm not going to spend time now apportioning blame on anyone, because some of the factors have clearly been due to circumstances beyond anyone's control. Because when somebody is sick, is hospitalized, we can't control those kind of situations. These developments take place in the context of two things. The first is that this committee is bound by the Constitution and the rules of the Assembly to complete its task, which is the consideration of the motion before us in a fair manner, within a reasonable time frame, without delay. Secondly, the PP, and she would have said this herself even today, who is the subject of this inquiry, has been suspended, and she indicated today is a year-long suspension from the 9th of June 2022 up until today. And therefore, when we commenced this process, she was already suspended, and we think that she too has a right to have this matter brought to finality. And so we've got to balance these important issues. If we fail to do so, it will leave her in a position of this matter hanging as a cloud over her, as it were, and it can never be said that such would be fair or right. We're fortunate that we have made important progress during this close to 11 months. It's a lot of work that has been done. We are indebted to the work and the journey that we've really traversed. The PP commenced with an oral testimony, and she covered what Advocate Mpofu said was the most important topics of CR 17 and SARS. We commenced with this testimony having the benefit of the PP's written statement, which responds to all these charges and which was her part of the audit she has been afforded since the hearings commenced. In addition, she has been allowed to cross-examine witnesses and call her own witnesses. The purpose of our oral testimony was to amplify this and then allow the evidence leaders and members to put questions to Advocate Mkhwebane as a subject of the inquiry. It is at this point that we seem stuck and not able to move forward because of issues of availability of counsels, amongst others, as we would have dealt with in the morning. In addition, the PP has taken issue with my instructions to the evidence leaders to take the committee through the records on Bosasa, CR 17 and SARS matters. She also objects to my proposal to proceed to deal with the inquiry in parts by concluding the evidence on statement A before we commence with part B. In addition, she raised concerns about funding and that she won't be in a position to fund this process when the additional 4 million is depleted. I've made my point about that we are not in a business of even depleting that by a cent, that 4 million. Because finances are certainly not in our control. I've also given regard to this, and I propose this as the way we must do things going forward, which might help to alleviate some of these issues and hopefully allow this committee to fulfill its mandate. And therefore, I want to raise the following issues for your attention and for our way forward. That I will direct that members and evidence leaders put in writing all questions they have on any subject matter in relation to the charges in the motion in writing. These questions will be collated, preferably by a topic, and provided to the PP to respond. 2, should the PP wish to respond orally, she will be afforded the opportunity to attend hearings not later than a day after being provided the questions, so that evidence leaders and members can put these questions to her orally, and of course, any questions that may flow from her answers. In turn, a counsel may re-examine her, as it were, to the extent it may be necessary to clarify anything that is arising from these questions. If her preference is to proceed, is to respond in writing, I will allow time and space for her to compile her answers and submit it under oath. Of course, no re-examination, if it is in writing, will be necessary. In the interim, while members and evidence leaders conduct this important exercise of putting their questions, if any, not saying that you must have questions when there might not be a need for any questions, I will allow the PP to submit anything further she wishes to submit in writing, in addition to the statements given to us, which is both part A and B, which may have arisen since we paused the hearings on the 31st of March. These 2 should be done under oath. Should the PP fail to answer the committee, the committee will have no choice but to make its findings based on the evidence before it, including the PP statements, part A and B, which were done under oath. Thankfully, much of the evidence before us is already in the form of sworn affidavits, which will assist us in our task. Members will be afforded an opportunity to consider these answers, which, as I say, may be oral or in writing. I will then allow the PP, via her counsel, an opportunity to make a closing statement orally or submit same in writing. I'll ensure that we provide more than one possible date for this to accommodate the availability issues. As we know, in this process, we've always been hit with those kind of issues. The evidence leaders will be expected to do a summation of evidence, and then the laborious work and process of report writing will have to happen once members have deliberated. These deliberations, of course, as I always indicate, we're not doing anything in a smoke-filled room, dark room, will happen transparently in the public. All of our deliberations. And whatever draft report will do, whatever recommendations we make, everybody will be with us as we do that. The process of report drafting will then have to take place, and this report in draft form submitted to members for consideration and adoption. Changes as proposed after such a discussion and agreed to will be made, and any members may submit a minority or contrary view to any findings which will be incorporated into the report. The report in draft form will be shared with the PP for comment, and this, colleagues, will form her additional and last Audi, or final Audi, before a decision on the adoption of the report will be made. To the extent the committee agrees to make changes to that draft report based on whatever that would have received as representations made in that regard. We'll then table the report, and the process will be led by the table, as we say, NA table, as our job would have been done. So if members are in agreement with this proposition as part of the way forward, I will henceforth issue directives to cater for these changes and set out a timeline in detail in which these steps will occur. This will be shared with everyone. Given the time and the cost considerations, practical difficulties with availability, there doesn't seem to be any other option except what we have throughout this process been patient about in doing. And as all of this is happening, there is going to be a concerted effort from this afternoon, based on the earlier discussion, to make sure that all of those issues that were ventilated this morning are fully attended to, in terms of what the discussion we've had after listening to the representative of the State Attorney's Office, Mr. Chowing. I want to pause there and therefore invite the honorable members. If there are members who wants to make any reflection or comment on this, I am now going to allow for that opportunity. I see the hand of the PP. I now recognize you.
Thank you, Chairperson. Indeed, I'm not the member of parliament. You've made that very clear and I've heard it. Thank you for giving me the opportunity. Chairperson, I wanted to clarify something with you. I think going forward, I will request that Ms. Ibrahim Fatima should be very honest and when advising members of the committee, because I mean, she should have raised the issue of what the SG said about the conflict from the beginning instead of allowing this matter to be discussed. Chair, I'm willing and able to engage with Public Protector South Africa to allow me to have legal representation of my choice, so that when I respond to those questions, which I should be assisted by legal representation, because I will not answer any question without my legal representation. So I hope that process we will move with speed. And Chairperson, I agree with you, saving on costs, exactly what I wanted to do. And it's strange that I wonder whether the state attorney, whatever they've done, they will do it for free, because what I know is that state attorney also charges. I wonder why PPSA decided to go brief state attorney instead of briefing Chane directly. So I think those are the issues. But what is critical, Chairperson, is that indeed, whatever you've mentioned now, the process which you are saying you are going to take is not provided for in the directives. And it's an unlawful process, which members, all of them are agreeing to that unlawful process. And fortunately, again, it's what exactly the late Tina Jumat Peterson said, but that will be revealed, that this is what you would want to do to circumvent the process. So I'll hear from you, Chairperson, as soon as the Public Protector South Africa has made sure that I have a legal representation, because unfortunately, they are the cause of all this mess with their letter of 1 March 2023, and now the issue of 4 million terminating Chane and everything. So I will proceed, Chairperson, with the process. So Chairperson, finally, can you, by you saying this, it means you are refusing to voluntarily recuse yourself, because I think that is very important. Yes, and then the second issue is that the issue of this constructive contempt of court, the issue of legal representation, but as well the issue that the matter is now before the SCA of your recusal, but now this is another matter of alleged extortion and corruption. So I just need to hear that information so that I can put it on record.
Thank you, PP. Thank you, PP.
Yes, yes, Chairperson. As I said, yes, I reject the proposal as presented, because anyway, I need to, as it's in violation of the Constitution. Hence, I said now the issue of legal representation. So I hope that issue is catered for. Thank you.
Thank you, PP. I did in my presentation indicated that I did indicate that that seems to be that now, and I will still put that to confirmation. All the members that would have spoken are in agreement with the proposal for the way forward. I indicated that once that's in place, I will issue the amended directives informed by that. So the point you're raising about directives has already been catered for. So, but also the issue of legal representation, I did indicate that that work is not stopping. It will continue, maybe even with much higher efforts and speed than we have done so far, because I've indicated that this committee has not
Sorry,
denied
Chairperson, you are breaking. I don't know whether it's on my side or it's on your side, but apology for just budging in.
Okay.
The thing is,
All right.
I don't hear you somewhere here.
No, thank you for that. Can you hear me now?
Yes, Chairperson.
Thank you. So no, I was saying, PP, that the issue of legal representation, that's a matter that we were seized with for it to reach that finality as would have started.
And you issue recuses.
Maybe the problem might be now on your side. Please mute. So we have been on this issue of assisting with issue of legal representation, and we're not going to tie on that. We're going to continue doing that. Everything else in relation to that will be attended to. I've made a point about if everybody agrees to this, the directives will be issued to conform with what we're discussing and agreeing to. I am still waiting. By 1 o'clock today, 56 minutes left, as indicated, that I will welcome an application for my recusal and will respond to that on Monday. I will attend to that when that reaches my space. So there should be no issues about that.